Okay. Good morning, friends. Today's session, we will be covering on the Insolvency and Bankruptcy Code 2016. What was the genesis behind the enactment of this IBC? It is a long story and it runs from the era when the CICA was enacted and the later on RDB Act, then SURF-SI, then BLRC committee in 2015. And thereafter, this IBC was enacted in 2016. So let us have an overview of the journey of enactment of the IBC. As you may be remember that in 1981, the Tiwari committee has recommended for the enactment of CICA, Sikh Industrial Companies Act. We will discuss about the CICA in the next slide. From 81 to 1991, the Narsingham Committee, that is also called the NC1, it recommended for enactment of this RDB Act. Then in 1998, the Narsingham Second Committee recommended for the enactment of the SURF-SI Act. Then in 2015, the Banking Law Reforms Committee recommended for the enactment of the code. And today, as we see, that this IBC has been enacted in 2016. So what was the CICA? Let us have an example that a promoter who has incorporated a company, established a company, avails loan from any banking and financial institutions by way of term loan or working capital and runs that company for 2, 3, 4 years and do not repay the dues of the banks and runs the company, but showing the losses in the balance sheets. And after 3 or 4 years, when the network has been eroded, because that may be due to the diversion of funds, siphoning of the funds, and the funds for which the loan has been availed by the company has not been utilized for that purpose. And when the banks are demanding their money back along with the interest and other charges, the company usually avoid to pay the bank's dues and may refer the matter to the BIFR, that is the Board for Industrial and Financial Reconstruction, BIFR. When the matter goes to the BIFR asks the banks and the financial institutions to provide some nursing approach to the company by way of soft loan, reducing the rate of interest, providing further working capitals, and all that. There was a limitation in the CICA that during the period when the matter has been referred to the BIFR, the moratorium was imposed as in the case of IBC, but there was not a fixed time bound when the moratorium will cease to effect. And further, there was not a time bound process to resolve the matter. That was the greatest lacuna in the Sikh Industrial Companies Act. Then how to recover the bank's dues? So Narsingham Committee, NC1, recommended for the enactment of the Recovery of Debts and Bankruptcy Act 1993. Under this act, when the dues towards the banks and financial institutions is up to 10 lakhs or more. There are special tribunals, which is called the DRTs, debt recovery tribunals, and banks can directly initiate action against the defaulting companies under that DRTs. Later on, the Nursing Second Committee recommended for the enactment of the SURFACI Act. The advantage of this SURFACI Act was that whosoever, means banks or financial institutions who have advanced loans, and when the borrower company is not repaying the dues to the banks, the concerning lender may exercise to take the possession of the secured assets without the intervention of the court by giving a notice under section 13(2) of the SURFACI Act, and after the lapse of 60 days from that notice, the bank can take possession with the assistance of the district magistrate. So there was a mounting pressure on the borrower company to come on the dais to pay the dues of the bank or to have a compromise settlement. Prior to this insolvency code, for individuals and unincorporated entities, we were having two acts. The one is the Presidency Towns Insolvency Act 1909, and the another one, the Provincial Insolvency Act 1920. Both these acts have been repealed by the enactment of this IBC. Thereafter, in 2015, the Bankruptcy Law Reforms Committee, under the chairmanship of Dr. T.K. Vishwanathan, this committee has recommended that now it is the time to enact a new law so that borrowers or the defaulter companies may not enjoy the funds provided by the banks and financial institutions. So this Insolvency and Bankruptcy Code was enacted in 2016. So this was the journey, how this code was enacted, right from the SICA, then RDB, then SURFACI, then BLRC committee's recommendation, and finally, as on today, we see this code was enacted in 2016, and during this 5-year journey, we have seen many litigations which are pending before the NCLT, Appellate Tribunal, High Court, and Supreme Courts, and there are various reforms or various amendments in the code as and when the requirement was necessitated. When we see the preamble of the IBC, it gives a clear picture to us that this IBC is to consolidate and amend the laws relating to reorganization and insolvency resolution of corporate persons, partnership firms, and individuals. Then it is a time-bound program. As we have seen in the SICA, the moratorium was imposed by the BIFR, but there was not a deadline, no time limit was fixed, but in IBC, there is a time-bound program. In IBC, the matter is, or the concept is, to maximize the value of the assets. Whenever a company avails the loan and that loan is not being repaid by the defaulter company, and it is not in position to run the business, whatever the assets that company is having, the value of that assets are day by day going to deteriorate. So the purpose of the IBC was to maximize the value of the assets. How the value of the assets will be maximized, that we will see in the coming slides. Next is to promote the entrepreneurship. If a person is not able to run a company, let the other persons come forward, take the ownership of the company, submit the resolution plan, and the ownership will be changed. So it also promotes the entrepreneurship among the industrial persons. And it also increase and stimulate the availability of the credit. When a company is defaulting, no lender will provide more funds to that company because the funds will be blocked, and the borrower, it will be very difficult to realize the funds from the borrower company. Further, this IBC take the interest of all the stakeholders. All the stakeholders means not even the promoters or the shareholders, but the creditors and the governments and other suppliers. So when the company is surviving, all the stakeholders, including the employees also, they are getting chance, they are getting remuneration, they are being rewarded. So these are the benefits which have been narrated in the preamble of the IBC. And foremost, the IBC have a provision to establish a regulator. Just like for the capital market, we are having the SEBI. For money market, we are having the Reserve Bank of India. Similarly, in this era, for this insolvency, we are having a regulator that is called the Insolvency and Bankruptcy Board of India, IBBI. The purpose of the code, as we have demonstrated, that is the time-bound resolution, maximization of the value of the assets, promotion of the entrepreneurship, ensuring the availability of the credit, and the foremost important is change in the priority of the government dues. In earlier enactments, the dues relating to the government was having a first priority. But in case of IBC, the priority has been changed and the dues towards the government has been kept after 3-4 points. And the first point is the resolution cost and workmen dues, creditors, like that. There are some judicial pronouncements which support the objectives behind the enactment of the IBC. In Binani Industries case, the appellate authority has pronounced that the first order objective of the IBC is resolution. Means we want a resolution plan from the resolution applicant, how the company may be revived in a given time frame. And the second order objective is the maximization of the value, so that if the existing promoters are not able to run the company may change the hands or the ownership may be changed, so that the value of the assets may not get deteriorated. And how to maximize the value, that is the second objective as announced in the Binani Industries Limited. And third and foremost is the promoting entrepreneurship, availability of the credit, and balancing the stakeholders, interest of the stakeholders. We take another example, that is the Swiss Ribbons Private Limited. In this, the Supreme Court has pronounced that the IBC is constitutionally valid. Whenever any act is pronounced by the parliament, get the assent of the president, there are some people who file an application before the Supreme Court and raise a question about the constitutional validity of that act. Similarly, for the IBC also, some of the persons filed a litigation before the Supreme Court and questioned about the constitutional validity of the IBC. The Supreme Court in this case, Swiss Ribbons, has upheld the constitutional validity of the IBC and observed that foremost and primary objective of the IBC is the reorganization and insolvency resolution of the corporate debtor in a time-bound manner. One of the important objective of the code is to bring the insolvency law in India under a single unified umbrella with the objective of speeding up the insolvency process. This was decided by the Supreme Court in a famous case, Innovative Industries Limited versus ICICI Bank. The title of this law is Insolvency and Bankruptcy Code 2016. It is not the Insolvency and Bankruptcy Act. Then why it is called the code? So we have to refer the definition of the code. And as per the Black's Law Dictionary, the meaning of the code has been defined as a collection or compendium of laws. It means the code is a collection of laws, rules, or regulations that are systematically arranged. And IBC is the first unified law in India dealing with the insolvency and bankruptcy of individual and legal entities. As you might have seen through the IBBI website also, that IBC is having its own code, then the rules are framed by the central government, then the regulations are framed by the IBBI. So it is a complete code, and it also covers the other laws which have been provided in schedules attached to the code from 1 to 12. Some of my friends may ask that what was the effect of this IBC? As we have seen earlier that in SICA, when the matter is referred to the BIFAR by the company promoters, the debtors, that is the corporate debtors, remain seated on their seats because they are having the overall control over the company. By the enactment of this IBC, there is a paradigmatic shift from the debtors in possession to the creditors in control. It means whenever the company is defaulting and the lenders are initiating CIRP, filing the case before the Adjudicating Authority, that is the NCLT, the moment the NCLT accepts the admission of initiation of CIRP, the balls or the ownership, or you may say the possession shifted from debtors to the creditors in control. It means the IRP or the RP, after its appointment by the NCLT, will form a committee that is called the Committee of Creditors, and then this committee will decide, COC will decide that who will run the company, how it will run the company. It means the powers of the existing board of directors are suspended and the creditors are having the control. So this is the major effect of the changes which have been brought out by the IBC. IBC have overriding effect on the other laws. Means whatever the laws has been enacted prior to the enactment of this IBC, or in future also, IBC in certain areas will have a overriding effect. And to support this, Section 53 and 178 of the IBC, the language of both these sections start with the words, notwithstanding anything contrary contained in any law enacted by the Parliament or state legislature for the time being in force, the proceeds from the sale of liquidation assets shall be distributed in the following order of priority. It means Section 53 has changed the order of priority. Similarly, Section 178 also starts with the same wording, notwithstanding anything contrary contained in any law enacted by the Parliament or the state legislature. So IBC is having the overriding effect. Section 238 of the code also supports that the provisions of this code shall have effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force or any instrument having effect by virtue of such laws. Let us have some judicial pronouncement on this Section 238. In the case of Principal Commissioner of Income Tax versus Moneth Ispat, the Supreme Court opined that IBC would override anything inconsistent contained in any other enactment, including the Income Tax Act 1961. Further, the Supreme Court, in a very famous case, in the Innovative Industries Limited versus ICICI Bank, in this case, the Maharashtra Relief Undertaking Special Provisions Act 1958 has put a moratorium, and there was a controversy between this Maharashtra Act and the IBC that which act will prevail. Since the IBC was enacted in 2016 and this Maharashtra Relief Undertaking Act was enacted much prior to the IBC, that is in the 1958, the Supreme Court opined that the non-obstacle clause of the IBC will prevail over the non-obstant clause in the MRUA, that is the Maharashtra Relief Undertaking. On account of this clause in the IBC, any right of the corporate debtor under any other law cannot come in the way of the IBC. So what we have discussed from SICA to the enactment of the IBC and the prevailing nature of any other enactment of the IBC, let us have what the IBC shares, that is the introduction of the IBC. The IBC came into the force on 28th of May 2016, and the central government has appointed different dates for the different provisions of this code. Since 2016, there have been 5 amendments in the IBC. During these 5 years, we have witnessed the 5 amendments, that major amendments have been made as and when the circumstances prevail. The ordinance has been promulgated by the government, and later on it was deemed as an act when the parliament was in session. So what it contains, that IBC have overall 255 sections having 12 schedules, and there are certain rules and regulations. Rules are framed by the central government, and the regulations are framed by the IBBI itself. The IBC have been divided in the 5 parts. Part 1 consists of section 1 to 3. This defines the preliminary definitions, the extent of the applicability of the code, title. Part 2 deals with the insolvency resolution and liquidation of the corporate persons. So it is limited to the corporate persons, whether the matter may be the insolvency resolution or the matter may be of the liquidation. Part 3 deals with the individuals and partnership forms. Part 4 relates to the regulation of insolvency professionals, insolvency professional agencies, and information utilities. and the miscellaneous part is covered under part 5th. The IBC infrastructure, if we see that this IBC is having the 4 pillars. One is the Insolvency Professional, Information Utility, then Adjudicating Authority, and the Regulatory Authority, that is the IBBI. Let us have a view on the Insolvency Professional, which has been defined in section 3, subsection 19. An IP is a regulated and licensed professional responsible for managing and overseeing the CIRP and or liquidation process of the corporate debtor and the resolution of bankruptcy process for partnerships and individuals. IBC gives various powers to the IBC. The first level of regulatory oversight of an IP is provided by the IPA, that is the Insolvency Professional Agency, with which the IP is attached or registered. And to support the IP, the concept of IPE, Insolvency Professional Entity, that is also a regulated service provider, which supports the IPs, is also recognized under the code. In this case, Asset Reconstruction Company versus Shim Water Treatment, the adjudicating authority held that RP is acting as an officer of the court, and any hindrance in the working of the CIRP will amount to contempt of the court. It means that IP is always appointed by the adjudicating authority, that is the NCLT, in case of the matter relates to the insolvency or liquidation process of the corporate debtor. And if any person is not assisting in the duties performed by the IP, that will be treated as a contempt of the court. So IP is acting as an officer of the court. And if any corporate debtor or its staff or its directors or promoters are not cooperating, the IP have a right to represent to the adjudicating authority, and the adjudicating authority will pass a suitable order in this behalf. Then there is a concept of information utility, which is the second pillar of this institutional infrastructure. The information utility provides the information which are being collected through the various sources from the lenders and others. And this information utilities collect, collate, authenticate, and disseminate financial information to be used in the insolvency resolution, liquidation, and bankruptcy proceedings. Then we have the third pillar, that is called the adjudicating authority. That is, for the corporate debtors, it is the National Company Law Tribunal, NCLT. And for the individual and partnership, the adjudicating authority is the DRT, that is the Debt Recovery Tribunal. Section 60, subsection 1, it provides that NCLT shall be the adjudicating authority for CIRP and liquidation of the corporate persons, including CDs and their personal guarantors. And for individual and partnership, section 79, subsection 1 provides that the DRT will be the adjudicating authority. It is pertinent to mention here that whenever a company is availing loans from any banks or financial institutions, the lender may put a condition that you may provide the guarantee of any of the directors or any individual having good net worth. The guarantee may be provided by any individual or the corporate also. When the guarantee has been provided by any individual person and the company is making default in repaying the dues of the lenders, the financial institutions may initiate CIRP against that corporate debtor. The lenders may also have a choice to directly initiate CIRP against the individual guarantor. Although the part third of this IBC, which deals with the individuals and the partnership firms, have not yet been notified. But if a person in his individual capacity has given guarantee to the corporate debtor, that individual case may be initiated in the NCLT. And where it has to be initiated, where the registered office of the corporate debtor is having. For example, a company is having a registered office in Delhi, Noida area, and Mr. X has given a guarantee to that corporate debtor so that the company may avail the finance from the banks. When the company is defaulting, bank have choice either to file CIRP against the corporate debtor, that is the company, or Mr. X in the same code, in the same NCLT, where the registered office of the company is. The fourth pillar, the third pillar, which we are discussing about the NCLT, if any person is agreed with the order given by the NCLT, there is a provision in the code that he may prefer an appeal to the appellate authority, that is called NCLAT, and the time limit has been fixed, that is the 30 days. And if any person is not able to file the appeal within the 30 days with a valid reason, and if the appellate authority accepts the reason, the limit can be extended up to maximum of the 15 days, that is 30 plus 15 days, 45 days, it can be filed. In normal cases, it is the 30 days. Similarly, if any person is aggrieved with the decision given by the appellate authority, appellate tribunal, there is a provision that the aggrieved person may prefer an appeal before the Supreme Court within 45 days of receiving that order. The fourth pillar which we are discussing here is the regulator. IBBA is the regulator. It was established on 1st of October 2016 under Section 188 of the IBC. It is having its head office in New Delhi. And IBBA is a unique regulator. It regulates the professionals involved and the transactions conducted. It has the regulatory oversight over the IPs, IPAs, IPEs, and IU means information utilities. IBBI also writes and enforces regulations for insolvency and bankruptcy process, namely the CIRP, the liquidation process, partnership and individual insolvency resolution, and partnership and individual bankruptcy. The status of the IBBI is a quasi-legislative, executive and quasi-judicial functions simultaneously. It also seeks to develop the profession and level of transaction. It is like a key pillar of the ecosystem responsible for implementing the IBC. When any of the matter is within the jurisdiction of the IBC, Section 63 of the IBC provides that no civil court or any other authority shall have jurisdiction on any matter in which the adjudicating authority or the appellate authority is empowered by the IBC to pass the order. Means except this adjudicating authority or the appellate authority, no other court is empowered to intervene in the cases. So far, we have discussed about the journey and some of the provisions related to the IBC at a glance. So this slide represents at a glance that part 1, part 2, and this part 6th and 7th, which deals with the preliminary, then CIRP, then adjudicating authority of the corporate persons, offenses and penalties respectively. So in today's slide, we will be discussing about these chapters right from section 1 to section 20. Many of our friends may be in a confusion that what is the meaning of the bankruptcy and insolvency. Sometimes these two words seems to be similar. The insolvency has been defined as any person or entity who is unable to pay off the debts if owes to other creditors on time, or as and when they become due and payable, then such person or entity is regarded as insolvency. Then there are two types of insolvency which we can witness, that is the balance sheet insolvency and cash flow insolvency. To understand these two types of insolvency, let us have an example that a company's balance sheet may be having good assets, having good value, but the company might be facing some liquidity problems, or the cash inflows are not generating enough to pay off the dues to the other creditors, or the installments, or the interest to the lenders. That is called the balance sheet insolvency. It means the debtor's assets are insufficient to meet its present liabilities. It is a preemptive measure that leads to invocation of the rehabilitation mechanism before the actual default of the debtor. It means the assets of the company are not sufficient. Contrary to this, in case of cash flow insolvency, the assets of the company are having a good value, but there is a mismatch in the cash flow. That is called the cash flow insolvency. Bankruptcy is a legal proceeding involving a person or business that is unable to repay outstanding debts. It is sometimes used interchangeably with the insolvency. In some jurisdictions, the term insolvency is associated with legal entities and bankruptcy with the natural persons. And in other jurisdictions, the differentiation is that insolvency is a state of inability to pay the liabilities or failure to pay liabilities, whereas bankruptcy is a status granted by the law. Thus, bankruptcy is a legal state of the insolvency. And what about the liquidation? Liquidation means the collapsing of an artificial person. It is the winding up of a company, which means the process of bringing a business to an end, distributing its assets to the creditors. In IBC, it is one of the outcomes of the resolution process. If the resolution process is not approved by the adjudicating authority, or the corporate debtor has not received any fruitful resolution plan from any of the resolution applicant, the last alternative before the NCLT is to order for the winding up or the liquidation of the company. If the resolution process fails, the debtor is ordered to be liquidated. Part 1 of the IBC section, it contains sections 1 to 3. It contains the title of the court, the extent and the commencement, application and some important definitions. IBC extends to the whole of the India. As regards the application of the IBC is concerned, Section 2 provides that it is applicable on all the companies, whether incorporated under the present Companies Act 2013 or under any previous company law. Any company governed by any special act. Any special act means any act which have been enacted by the parliament, and through that process the company came into existence. Then any limited liability partnership, any other body incorporated under any law as specified by the central government, then personal guarantors through the corporate debtors, partnership firms and partnership proprietorship firms, and individuals other than the persons referred to in class E. So Section 2 applies to all these persons from A to E in relation to their insolvency, liquidation, voluntary liquidation, or bankruptcy, as the case may be. So some of the important definitions before we discuss about the CIRP, it is pertinent to have the clarification on this definition which has been provided under Section 3. The claim. Claim means a right to payment, whether or not such right is reduced in judgment, fixed, disputed, undisputed, legal, equitable, secured, or unsecured. Class B specifies that claim means a right to remedy for breach of a contract under any law for the time being in force. If such breach gives right to a right to payment, whether or not such right is reduced to judgment, fixed, matured, unmatured, disputed, undisputed, secured, or unsecured. Section 3, subclass 7 defines the meaning of the corporate persons. Who may be the corporate persons? So corporate persons may be the company. The definition of the company has been defined under Section 2, subsection 20 of the Companies Act. And LLP, Section 2, subsection 1, clause N of the LLP Act 2008. So both these company and LLP, these are termed as the corporate person. And any other person incorporated with the limited liability under any law for the time being in force, but shall not include any financial service provider. So these financial service provider has been excluded from the definition of the corporate persons. Who are these financial service providers? Means the banks, FIs, insurance companies, asset reconstruction companies, mutual funds, collective investment schemes, CIS, or pension funds. These entities have been excluded from the definition of the corporate persons. Now, Section 227 has given power to the central government to notify financial sector providers. The notification of 18th November 2019 specified that central government, in consultation with the RBI, notify that the insolvency resolution and liquidation proceedings of the following category of financial service providers shall be undertaken in accordance with the provisions of the code. That is the NBFC, which include the housing finance companies, which are having the asset size of rupees 500 crore or more as per the last audited balance sheet. So as per this notification, the government has power under Section 227 of the code to notify any financial sector providers. Now the case law on this Section 3/7 is that in the case of Hindustan Construction Company, a CIRP was sought to be initiated against the National Highway Authority of the India, NHAI. Everybody knows what are the functions of the NHAI. The apex court, Supreme Court, opined that the NHAI is a statutory body that functions as an extended limb of the central government and performs governmental functions that cannot be taken over by an RP under the IBC or any other corporate body, nor can such authority ultimately be wound up under the IBC. So for all these reasons, it is not possible to either read in or read down the definition of corporate person in section 3/7 of the IBC. Now the corporate debtor. It means a corporate persons. Who is the corporate person? Any company or LLP who owes a debt to any person. If a person extends guarantee for the loan transaction concerning a principal borrower, not being a corporate person, it would still be covered within the meaning of expression corporate debtor in section 3, subsection 8. This was decided in the case of Lakshmi Surana versus Union Bank of India. So, in the definition of the corporate debtor, an individual who has given a guarantee for availing loan by any company, that individual will also be treated as a corporate debtor within the meaning of this section 3, subsection 8, as decided by the Supreme Court in Lakshmi Surana. Now, who is the creditor? As a layman, we understand that the person who has given finance or credit facilities, he is the creditor. So the creditor means any person to whom a debt is owed and includes a financial creditor, operational creditor, secured creditor, unsecured creditor, and a decree holder also. So in this definition, not even a person who has given financial assistance to a company, but any other person who has provided the goods or supplied the services is also termed as a creditor. The creditor may be secured or he may be unsecured. And the person who has initiated a case against the company and a decree has been awarded by the competent court, that decree holder is also to be treated as a creditor as per the definition given in the IBC. In the case of Nikhil Mehta and Sons, the appellate authority has opined that the parties who have entered into agreement for purchase of flat or shop or any immovable property which contains a clause of assured or committed returns are also termed as financial creditor under this code. However, in the case of Franklin Templeton, as you might have observed that during this COVID pandemic, the units issued by the Franklin Templeton mutual funds went below the par value and there were some litigations. So the Supreme Court in this case opined that to equate the unit holders in mutual funds with the creditors under the code will be unsound and incongruous. So the persons who have invested in that mutual fund will not be treated as a creditor. Now, what is the debt? Debt means any liability or obligation in respect of a claim. Claim, definition of claim we have just read out. So debt means a liability or obligation in respect of a claim which is due from any person and includes a financial debt and operational debt. So both this debt, financial and operational debt, has been covered under the definition of the code. It is latently and patently clear that once the debt is converted into capital, it cannot be termed as financial debt as decided in the case of Rita Kapoor versus InvestCare Real Estate LLP by the appellate authority. Many of the lenders have such a clause in their loan agreement that after a certain period, say 1 or 2 or 3 years, if the company is not able to repay the dues, that dues will be converted into the capital and the lender will be provided the capital to the extent of the loan outstanding. So in this case, it was opined by the appellate authority that once the debt is converted into the capital, it cannot be termed as financial debt. Before that, it was a financial debt, but after conversion, it will not be treated as a debt. The IBC code revolves around the one word, that's the default. A company may avail the loan facility, it is repaying the dues of the lenders, then there is no problem. The cause of action arises when there are dues and the concerning company has defaulted in repaying the dues. Then all the litigations and initiation of the CIRP comes into the picture. So it is very essential to clarify the meaning of the default. Default means the non-payment of the debt when whole or any part of the installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be. Let us take an example of this. That a bank has given a term loan to any company and the installment has been fixed, say 10 lakhs rupees per month, that is the EMI, along with the interest. The company paid the installments regularly up to 2 years, and later on it defaulted. Then the account of the company, loan account of the company, was classified as non-performing advances in the books of the bank. And what happens when any of the account is classified as an NPA? The bank exercises to recall the dues from the company. So there are various measures. Either the lender may ask to pay the installment amounts which have become due, or the bank may recall the entire advances since the account has become NPA. So that wordings has been used in this definition of the default, that when whole or any part of the installment of the amount of debt has become due and payable and is not paid by the debtor or the corporate debtor, as the case may be, then the default has occurred. In the case of Park Energy Private Limited versus Syndicate Bank, the appellate authority opined that mere fact of debt being due and payable is not enough to justify the initiation of CIRP at the instance of the financial creditor unless the default on the part of the CD is established. It means that the corporate debtor has defaulted in repaying the dues. Outstanding may be due, but the company has not defaulted. As and when the lender has demanded, the company is regularly paying. As and when it has become due, the default has not been arrived. But when the company is not repaying the dues on the demand made by the financial institution or the lender, the default comes into the picture. Rest of the definitions: financial information, section 3, subsection 13. What type of financial information in relation to a person means one or more of the following categories of the information, namely records of the debt of the persons, record of liabilities when the person is solvent, records of assets of the person over which the security interest has been created, records, if any, of instances of default by the person against any debt, records of the balance sheet and cash flow statements of the person, and such other information as may be specified. So what types of information are termed as financial information that has been prescribed in section 3, subsection 13. Now the term financial institution has also been defined. It means a scheduled bank. A financial institution which has been defined under section 45I of the RBI Act, and any public financial institution as defined under section 2, subsection 72 of the Companies Act 2013, and such other institutions as the central government may by notification specify as a financial institution. Then the financial product. Financial product means securities, contracts of insurance, deposits, credit arrangements, including loans and advances by banks, financial institutions, retirement benefit plans, small savings instruments, foreign currency contracts, other than contracts to exchange one currency, whether Indian or not, for another, which are to be settled immediately, or any other instruments as may be prescribed. These all are termed as the financial products. Then financial services. What type of financial services? That is accepting of deposits, safeguarding and administrating assets, effecting contracts of insurance, offering, managing, or agreeing to manage assets consisting of financial products belonging to the other persons, and renting and agreeing for consideration, that is the buying, selling, or subscribing to the financial product, availing of financial services, exercising any right associated with financial product or financial services, establishing or operating an investment scheme, maintaining or transferring records of the ownership of the financial product, underwriting of issuance of subscription of financial product, selling, providing, or issuing stored value or payment instrument, or providing payment services. These all are included in the financial services. Then, who is the person which may be termed as a financial service provider? It means a person who is engaged in the business of providing the financial services, which has been elaborated in section 3, subsection 16, in terms of the authorization issued or registration granted by a financial service sector regulator. Who are the financial sector regulator? That is the RBI, insurance, IRDAI, like that. Then these are the financial sector regulators: RBI, SEBI, IRDAI, pension fund and regulatory authorities, and any such other regulatory authorities as may be notified by the central government. Then insolvency resolution, insolvency professionals, which has been defined under section 3, subsection 19, means a person who has been enrolled under section 206 with an insolvency professional agency as its member and registered with the IBBI as an insolvency professional under section 207. So for being an insolvency professional, one has to pass the examination conducted by the IBBI, undergone some certain trainings of certain hours, and then he has to apply through its IPA for registration. And when everything is fine, the IPA may recommend to the IBBI for grant of registration to the concerned IP. IPA. It means any person registered with the board under section 201 as an insolvency professional agency. Right now, we are having only 3 IPAs which are registered with the IBBI. That is Indian Institute of Insolvency Professionals of ICAI, then ICSI Institute of Insolvency Professional, and the third one is the Insolvency Professional Agency of Institute of Cost Accountants of India. So 3 professional bodies, that is ICAI, ICSI, and ICSI, that is the cost accountant body. These 3 institutions have got registered through the subsidiary as an IPA. The information utility means a person who is registered with the board as an information utility under section 210. Presently, there is only one company, that is the National E-Governance Services Limited. This is the first company registered as the information utility with the IBBI. The definition of the person has been defined under section 3, subsection 23, It means the definition is given as an inclusive definition. It means it is not an exhaustive definition. Some other items may also be included. So the definitions starts with the words person includes. It means it is an inclusive definition. So it includes individual, HUF, company, trust, partnership, LLP, and any other entity established by HTTU, and includes a person resident outside India. Then we are talking about this trust, subsection D. So there was a case in JK Jute Mill Mazdoor Morcha versus Jugilal Kamlapat Jute Mills Limited. In this, the Supreme Court has opined that trade union is an entity established under the Institute, the Trade Unions Act 1926, and is therefore a person under Section 3, subsection 23 of the Code. Students are requested to kindly raise their query if they are having any issues or any clarification they want from my side. They may write on this admin login, and I will try to resolve the queries instantly or in the next session by uploading the answers on this admin portal. So you may raise the queries if you are having any doubt. So far we have discussed the definition part of the IBC. The main part of the CIRP will be covered later on. So this slide conveys about the property, the definition of the property. It includes, again, this definition is an inclusive definition. It means it is not an exhaustive definition because the words used in the starting is the property includes. So money, goods, actionable claims, land, and every description of property situated in India or outside India. Remember that property, not only the property situated in India, but the property situated outside India has also been included in the definition of the property, because a company may having the overseas transaction, overseas assets, and whenever any CIRP is to be conducted, the insolvency professional has to take the custody of that property, whether the properties are situated in India or outside India. And every description of the interest, including the present or future or vested or contingent interest arising out of or incidental to the property. Then secured creditors. It means a creditor in favor of whom the security interest is created. In the case of TFCI, Tourism Finance Corporation of India, the appellate authority opined that the state tax officer does not come within the meaning of secured creditors as defined in Section 3, subsection 30, read with Section 3, subsection 31. So the tax revenue authorities are not to be treated as a secured creditors. Then security interest. It means the right, title, or interest, or a claim to a property created in favor of or provided for a security creditor by a transaction which secures payment or performance of an obligation and includes mortgage, charge, hypothecation, assignment, and encumbrance on any other agreement or arrangement securing payment or performance of any obligation of any person. So the security interest covers all this type of words which are related to mortgage, charge, hypothecation, assignment, encumbrance, etc. provided that the security interest shall not include a performance guarantee. Guarantees are maybe financial guarantees and the performance guarantees. So students, please note that performance guarantees are not part of the definition of security interest. So let us have the question answer session. So far we have discussed. You may write your answer in this admin portal. The provisions of the IBC shall not apply to proprietorship firms, partnership firms, limited liability partnership, or none of them, which is the correct option. Any answer? The answer is none of the above. Why it is none of the above? Section 2 of the IBC already includes the proprietorship firms, partnership firms, and limited liability partnership. These are also covered under the IBC. So the option is none of the above. A right to payment, whether or not such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured, is called as charge, mortgage, claim, or hypothecation. You may write your correct option on the admin portal so that I may view your answers. So the correct answer is the claim. Why? The definition of the claim has been provided under section 3, subsection 6, clause A. A corporate person who owes a debt to any person is called. 4 options are given: corporate debtor, corporate creditor, corporate guarantor, and corporate surety. Which one is the correct? So let us have an answer of this. It is the corporate debtor. Reason being, section 3, subsection 8 provides the definition of corporate debtor. Default means non-payment of debt when whole or any part or installment of the amount of debt has become due and payable, and each fill up the blanks by the debtor or the corporate debtor as the case may be. Options are repaid, not paid, not settled, not compromised. So the correct answer is not paid. The reason, section 3, subsection 12 defines the definition of default. Which among the following is not termed as financial institution as per the provisions of the code? Scheduled bank, non-scheduled bank, financial institutions as defined in section 45I of RBI Act, and public financial institution as defined in section 2, subsection 72 of the Companies Act. The correct answer is non-scheduled bank. Reason being, it has been defined under section 3, subsection 14. So friends, let us have a break for 10 minutes. We will resume within 10 minutes. So let us have a break. Then we will start for chapter first of the part second, that is the insolvency resolution and liquidation or the corporate person. Some of the definitions are given under this section 5, and later on we will discuss about the CIRB provisions today. Yes, friends. Now we will be discussing on part 2 of chapter 1, that is the section 4 and section 5. Section 4 provides the application of this part. This describes that this part shall apply to matters relating to insolvency and liquidation of corporate debtors, where the minimum amount of default is 1 lakh rupees. So what is the definition of default that we have discussed in our previous slides? If any default is rupees 1 lakh, that is the minimum amount of default, then any person may invoke this section 4. Then the proviso of this section states that the central government may, by notification, specify the minimum amount of default of higher value, which shall not be more than 1 crore rupees. So this minimum amount of default that is provided in subsection 1, that is 1 lakh rupees, can be increased by the central government up to 1 crore rupees. Then the second proviso relates to the pre-packaged insolvency resolution process, which we will be discussed later on. This proviso provides that central government may, by notification, specify such minimum amount of default for higher value, which shall not be more than 1 crore rupee for matters relating to the pre-packaged insolvency resolution process, in short, PPIRP, under chapter 3A. This chapter 3A has been inserted by way of an amendment in the IBC. Now let us discuss some of the prominent definitions which have been provided under section 5. That is the corporate applicant. Section 5, subsection 5. Corporate applicant means a corporate debtor. Who is the corporate debtor? Means any company or LLP, or a member or partner of corporate debtor who is authorized to make an application for the CIRP or the PPIRP, as the case may be, or an individual who is in charge of managing the operations and resources of the corporate debtor, or a person who has control and supervision over the financial affairs of the corporate debtors. So whenever any application for initiation of CIRP is to be filed, then who will be termed as a corporate applicant? So this subsection provides 4 criteria, that is corporate debtor, any member of corporate debtor or PPIRP, or an individual who is in charge, and the person who has the control. Corporate guarantor means a person who is the surety in a contract of guarantee to a corporate debtor. So guarantor may be of 2 types. An individual person, suppose a director has given a guarantee while availing loan facility from banks in favor of that corporate debtor, and that guarantor may be the corporate guarantor also. So a company may also give guarantee to the other company. If CIRP has been initiated against the corporate debtor, the insolvency and bankruptcy process against the personal guarantor can be filed under section 60, subsection 2, before the same NCLT and not before the DRT. As we have seen in our earlier slides, that part 3 of this IBC relates to the initiation of insolvency proceedings pertaining to individual and partnership. But in case where an individual, not a corporate person, but an individual has given a guarantee to a company and the company has defaulted, that in that case where the case against the case against the individual guarantor shall be filed. As we have given the example that a company is having the registered office in Delhi, company has defaulted, an individual person has given a guarantee to the bank in favor of that company, then the lender have the choice either to initiate CIRP against the company, or it may initiate the CIRP against the individual person, or simultaneously with against both the person. So where the application shall be filed where the registered office of that company is situated, that is the Delhi. So if that individual is residing in any other city, immaterial of the fact, the initiation of CIRP against that individual guarantor shall be initiated against the that person in the city where the registered office of the company is situated. Then corporate guarantor, without initiating CIRP against the principal borrower, it is open to the financial creditor to initiate CIRP against under Section 7 against corporate guarantors, as the creditor is also the financial creditor for corporate guarantor. As we have mentioned that the lender have the option either to initiate CIRP against the company, or without initiating CIRP against the company, but to initiate the CIRP against the guarantor. So lender have both the choices, either to sue company or the guarantor, or simultaneously against both of them. The corporate guarantees given by the CD can be invoked only in the event of default on the part of the borrowers. So when a person will invoke the guarantee can be invoked only when the corporate debtor has made a default in repayment of the dues of the lenders, not before that. In the case of Karur Vysya Bank, the NCLT Chennai has opined that it makes no difference as to whether the corporate person stood as guarantor to an individual or a corporate person, and as so long as the obligation in respect of a claim is due from a corporate person falling within the definition of financial debt, then it is obvious that the creditor can proceed under Section 7 of the code against such corporate person. So matter is clear whether the guarantor is having an individual capacity or in the capacity of a corporate entity, and the corporate debtor who is the principal borrower. So the lender can initiate CIRP either against the corporate debtor or the individual guarantor who has given the guarantee. Now, dispute. Dispute includes a suit or arbitration proceedings relating to the existence of the amount of debt. Dispute may also be relating to the quality of the goods or services, or the breach of a representation or warranty. So in the IBC, 3 types of dispute has been mentioned, that is the existence of the amount, quality of the goods, and breach of representation or warranty. Then how to test the existence of a dispute? Whether the corporate debtor has raised a plausible contention requiring further investigation, which is not patently feeble legal argument or an assertion of facts unsupported by evidence. Secondly, whether the defense is not spurious, mere bluster, plainly frivolous or vexatious, or a dispute if it is truly exists in fact between the parties, which may or may not ultimately succeed. This has been given or opined by the Supreme Court in the famous case of Mobile X Innovations Private Limited. Financial creditor, as defined under Section 5, subsection 7, it means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred to it. A company may have the loan facility from any lending institutions, and later on, if that loan has been assigned to another company, that another company may be treated as a financial creditor. So either the original loan agreement with the original financial creditor, or where the original financial creditor has assigned such loan to any other person, that another person will also be treated as the financial creditor. In the case of State Bank of India versus Meenakshi Energy, the adjudicating authority opined that mere invocation of pledge of shares will not result in automatic conversion of debt into equity and repayment of the debt. What happened in this case, that the company has pledged some of its shares with the lender. When the company defaulted in repaying the dues, the lender has exercised its right as a pledgee and converted that share equity shares debt into the equity shares toward the repayment of the debt. So in this judgment, this adjudicating authority opined that mere invocation of pledge of shares will not result in automatic conversion of debt into equity and repayment of the debt. Now, meaning of the financial debt as defined in section 5, subsection 8, it means a debt along with interest, if any, which is disbursed against the consideration for time value of money and includes. These two words are very important. Against the consideration for the time value of money and includes. So time value factor necessarily should be included, and includes. It means, again, this definition is having a inclusive characteristics. So anything else which has not been described in subsection 8 can also be included. So this inclusive definition further states that money borrowed against payment of interest, any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent, then any amount raised pursuant to any note purchase facility or issue of bonds, notes, debentures, loan stock, or any similar instrument, the amount of any liability in respect of any lease or hire purchase contract which is deemed as a finance or capital lease under the Indian accounting standards or such other accounting standards as may be prescribed, receivables sold or discounted other than receivables sold on non-recourse basis. Further, class F, it is very important that any amount raised under any other transaction, including any forward sale or purchase agreement that is having the commercial effect of borrowing. Then explanation. This explanation has been inserted by way of amendment later on. This explanation suggests that any amount raised from an LOT under a real estate project, it means the home buyers, shall be deemed to be an amount having the commercial effect of borrowing. It means the first, although it was clear, but by way of explanation inserted by way of an amendment, the IBC, in the IBC, this has been more elaborately explained that whosoever have booked the flat under any real estate project shall be deemed as a financial creditor because it is having a commercial effect of borrowing on the part of the builders or developers. The expression LOT and the real estate project shall have the meaning respectively as assigned in the RERA Act. Then further, any derivative transactions entered into in connection with protection against or benefit from fluctuation in any rate or price, and for calculating the value of any derivative transaction, only the market value of such transaction shall be taken into account, and any counter indemnity obligation in respect of a guarantee, indemnity, bond, documentary letter of credit, or any other instrument issued by a bank or financial institution, any amount of any liability in respect of any guarantee or indemnity for any of the items referred to in subclass A to H of this class. So it has been defined the meaning of the financial debt, it includes all these parameters from A to H: money borrowed, credit facility, bonds and notes, purchase contract, receivables sold or discounted, and the foremost important, by way of an explanation, that the housing loan, home loan LOTs, then this derivative transactions, and any counter indemnity obligations. Now, the meaning of financial debt. The definition of financial debt does not expressly exclude an interest-free loan. But we have discussed in our previous slides that if any loan is given by the lender which have any time value of money, but in this case, the Supreme Court, in the matter of Orator Marketing Private Limited, has opined that even if the loan is bearing no interest or say interest-free, even then it will be treated as a financial debt. Financial debt would have to be construed to include interest-free loans advanced to finance the business operations of the corporate body. Further, in the case of Narendra Kumar Agarwal, the appellate authority has opined that if inter-corporate deposits is made for a certain period, which was to be paid back with interest, such transaction will fall within the definition of financial debt. Then case law on the guarantors, also liable. In this case, the appellate authority opined that a financial debt includes a debt owed to a creditor by a principal and the guarantor. An omission or failure to pay the debt by the guarantor when the principal sum is claimed comes within the scope of default under Section 3, subsection 12. Therefore, a CIRP can be initiated by a financial creditor who had taken guarantee for the debt against the guarantor for failure to repay the money taken by the principal borrower. Case law on home buyers. In the case of Pioneer Urban Land and Infrastructure Limited, the Supreme Court opined that while dismissing the various petitions filed by the builders, Supreme Court upheld the constitutional validity of the status of the LOT as financial creditors. In this case, the home LOTs initiated CIRP against the Pioneer Urban Land, and the developer or this company has challenged the constitutional validity of this provision, and the Supreme Court has opined that it is constitutionally valid. Supreme Court clarified that home buyers are treated as financial creditors so that they can trigger the IBC under Section 7 and take their rightful place on the COC when it comes to making important decisions on the future of the construction company, which is executing the real estate project in which such home buyers are ultimately to be housed. It was also observed that in real estate projects, money is raised from the LOTs against consideration for time value of money, and the amount raised from the LOTs under the real estate projects are subsumed within Section 5, Subsection 8, Clause F, even without adverting to the explanation introduced by the Amendment Act. As we have seen in our previous slide, that explanation was added to this Clause F of Subsection 5 of Subsection 8 of Section 5. This puts beyond doubt the fact that LOTs are to be regarded as financial creditors within this Section 5, Subsection 8, Subclause F of the IBC. Now, initiation date. It means the date on which a financial creditor, corporate applicant, or operational creditor, as the case may be, makes an application to the adjudicating authority for initiating CIRP or PPIRP, as the case may be. So it is called the initiation date. It is not the commencement date. It is the students have to make it clear that initiation date is different from the insolvency commencement date. Initiation date means the date when the financial creditor or the operational creditor has filed the application for initiation of CIRP with the adjudicating authority. It means the date when the application is filed. That is called the initiation date. And what about the insolvency commencement date? It means when the application for admission of an application for initiation of CIRP has been accepted by the adjudicating authority under section 7, 9, or 10, as the case may be. Because there may be chances that when a financial creditor has submitted an application, the application may not be complete, then the NCLT may either accept it or reject it and give the time to the applicant that within that prescribed time, it has to fulfill the obligations which are commensurate with the filing of the application. So there is a difference between the initiation date and the insolvency commencement date. Then insolvency resolution process cost. What is the process cost? It means the amount of untrimmed finance and costs incurred in raising such finance, the fees payable to any person acting as a resolution professional, any cost incurred by the resolution professional in running the business of corporate debtor as a going concern, any cost incurred at the expense of the government to facilitate insolvency resolution process, and any other cost as may be specified by the IBBI. Then what is the period? Insolvency resolution process period means the period of 180 days beginning from the insolvency commencement date and ending on the 180th day. This is the process insolvency resolution process period. What is the meaning of untrimmed finance? It means the financial debt raised by the resolution professional during the insolvency resolution process period or the corporate debtor during the PPIRP period, as the case may be, and such other debt as may be notified. Then liquidation cost, liquidation commencement date, and liquidator. It has been defined under section 5, subsection 16, 17, and 18. Liquidation cost means any cost incurred by the liquidator during the period of liquidation, subject to such regulations as may be specified by the IBBI. Commencement date, its liquidation commencement date, means the date on which the proceedings for liquidation commence in accordance with section 33 or 59, as the case may be. And who is the liquidator? It means the insolvency professional appointed as liquidator in accordance with the provisions of chapter 3rd or chapter 5th of this part, as the case may be. So far, we have discussed the definition of the financial creditor. Now, creditor also includes the financial creditor as well as the operational creditor. Then what is the definition of the operational creditor? It means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. So what is used? Operational debt. Operational creditor means a person to whom an operational debt is owed. Then what is the meaning of operational debt? It means a claim in respect of provisions of goods or services, including employment, or a debt in respect of payment of dues arising under any law for the time being in force and payable to the central government, state government, or local authority. It means any person who is providing the services or supplying the goods to any company, that supplier is to be treated as operational creditors. Moreover, any employee who is serving with that company and he has not been paid, it means the employee is having the legal right to have the salary. That employee is also to be treated as an operational creditor because he has provided or supplied the services to the company of his skills or labor. Now comes to the related party to a corporate debtor. Section 5, subsection 24. Section 5, subsection 24 relates to the related party in relation to a corporate debtor. Another section 5, subsection 24A was inserted by way of amendment in the IBC that also relate to the related party, but in relation to an individual. So in this slide, in this subsection 24, related party in relation to a corporate debtor means a director or partner of the corporate debtor, or a relative of the director or partner of the corporate debtor, any KMP of the corporate debtor or relative of the KMP, LLP or partnership firm in which a director, partner, or manager of the corporate debtor or his relative is a partner, a private company in which a director, partner, or manager of the corporate debtor is a director and holds, along with his relatives, more than 2% of its share capital, then public company in which a director, partner, or manager of corporate debtor is a director and holding, along with the relatives, more than 2% of its paid-up share capital. Similarly, any body corporate whose board of directors, managing director, or manager in the ordinary course of business acts on the advice, directions, or instructions of a director. Similarly, any LLP or partnership firm whose partners or employees in the ordinary course of business acts on the advice, directions, or instructions of a director, partner, or manager of the corporate debtor. Any person on whose advice, directions, or instructions a director, partner, or managing manager of the corporate debtor is accustomed to act. Then a body corporate in which a holding subsidiary or an associate company of the corporate debtor or subsidiary of a holding company to which corporate debtor is a subsidiary, any person who controls more than 20% of the voting rights of the corporate debtor on account of ownership or a voting agreement, any person in whom the corporate debtor controls more than 20% of the voting right on account of ownership or voting agreement, any person who can control the composition of the board of directors or corresponding governing body of the corporate debtor, and any person who is associated with the corporate debtor on account of participation in policy making processes of the corporate debtor, or having more than 2 directors in common, interchange of managerial personnel, and provisions of the essential technical information to or from the corporate debtor. So there is a long list which has been provided in 5 subsection 24 in relation to the corporate debtor. Similarly, this subsection 24A was inserted by way of an amendment. It also have similarly a long list who are the persons which are deemed as a related party in relation to an individual. A person who is a relative of the individual, a partner of the LLP, person who is a trustee of a trust, private company in which the individual is a director, public company in which that individual is a director, body corporate whose board of directors, managing directors are accustomed to act in the ordinary course of business, limited liability partnership or partnership firm whose partners or employees in the ordinary course of business act on the advice, directions, or instructions of the individual, a person on whose advice, directions, or instructions the individual is accustomed to act. Then related party in relation to an individual, that is also having a clause that a company where the individual or the individual along with the related party own more than 50% of the share capital of the company or controls the appointment of the board of directors of the company. Now, by way of explanation for the purpose of this class, what is the meaning of the relative that has been defined? It includes the so many relative, and class B of this explanation provide that wherever the relation is that of son, daughter, sister, or brother, their spouses shall also be included. So there is a long and exhaustive list which has been provided in section 5, subsection 24 and 24A. Now we come to the definition, that is the resolution application. Then what is the meaning of resolution applicant? Who can be a resolution applicant? It means a person who individually or jointly with any other person submits a resolution plan to the resolution professional pursuant to the invitation made under section 25, subsection 2, clause H, or pursuant to section 54K, as the case may be. 54K relates to the PPIRP, which we will discuss later on. Then resolution plan. It means a plan proposed by the resolution applicant for insolvency resolution of the corporate debtor as a going concern in accordance with part 2. A resolution plan may include provisions for the restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. So resolution plan may have the provision of merger also. It may have the provision of the amalgamation or demerger or transfer of the ownership by a third person who have shown interest by way of resolution plan by the resolution applicant. Again, the resolution professional for the purpose of this part means the insolvency professional appointed to conduct the CARP or PPIRP as the case may be, and includes an interim resolution professional. There is a difference between insolvency professional and resolution professional. Insolvency professional is the person who has passed certain examination, who has conducted certain hours of training, and has been registered with the IPA and IBBI. That is the insolvency professional. The insolvency professional who has been assigned the task of conducting this CARP and has been appointed by the Adjudicating Authority, that is called the resolution professional. So the person, insolvency professional who has been appointed by the Adjudicating Authority to initiate or to conduct the CARP proceedings is called as a resolution professional. So basic criteria that resolution professional should be insolvency professional who has passed certain examination, certain hours of training, and having the registration from the IPA and IBBI. And later on, this has been appointed by the Adjudicating Authority. Then voting shares. Voting share means the share of voting rights of a single financial creditor in the committee of creditors, which is based on the proportion of financial debt owed to such financial creditor in relation to the financial debt owed by the corporate debtor. A company, let us have an example, a company have availed 100 crores of loan from different banks. So in case when the company makes default in repaying the dues to the bankers, then each of such bankers or lenders will have the voting rights in proportion of their share of loan outstanding in the books. Suppose A bank is having 30 crores, B bank is having 50 crores, and like that. So each of the lender will having the voting right up to 30%, 50%, 20%, like that. Let us revise whatever we have discussed by way of an MCQs. That dispute includes a suit or arbitration proceedings relating to 4 options have been given: the existence of the amount of debt, the quality of goods or services, the breach of a representation or warranty, and all of the. You may write your option in the admin portal so that I may view. The correct answer is all of the above. Reason being section 5, subsection 6. The another question, any person to whom a financial debt is owed is called financial creditor, operational creditor, credit provider, or money lender. So the correct answer is financial creditor, reason being the definition provided in section 5, subsection 7. Insolvency commencement date means the date when the application for initiation of CIRP is filed with the adjudicating authority, admitted by the adjudicating authority, accepted by the adjudicating authority, or agreed by the adjudicating authority. Insolvency commencement date. It is not the insolvency initiation date, it is the commencement date. So commencement date means when the application has been admitted by the NCLT. The reason being section 5, subsection 12. Let us have another question. The insolvency resolution process period means the period of 4 options, 90 days, 180 days, 270 days, and 330 days. Which is correct? Vidula has given the correct answer for the last query. So the correct answer is, some more answers are coming. No, it did not see 9 option. Vidula has mentioned 9 का option है. That is B, 180 days. It is correct. Reason being the section 5, subsection 14. Let us have last MCQ of this chapter, that a resolution plan means a plan proposed by, fill up the blanks, for insolvency resolution of corporate debtor as a going concern. Resolution plan means a plan proposed by, now we have to fill up 4 options: resolution professional, insolvency professional, resolution applicant, or corporate debtor. Who is to submit resolution plans? The correct answer is the resolution applicant. 2 persons have mentioned the correct answer. That is mentioned in section 5, subsection 26. Now we shall start with the part 2 of this IBC code, which consists of section 6 to section 32, which relates to the CIRP proceedings. Section 6, 7, 8, 9, and 10. These are the very much important sections. And section 13 and 14 that relates to the moratorium declared by the adjudicating authority. Let us have a viewpoint of this part. Section 6, persons who may initiate CIRP. Then who can initiate? Under section 7, only the financial creditor. Section 8, by operational creditor, and how it will proceed, that has been mentioned in this section 8. Then section 9, we may take some break. Some officers from the ICAI may be addressing to the students. So, hello, Nisarji. Hello. Hello. हाँ निसर्ग जी. if you want to have the session by Madam, then I may break for a while.
So, hello.
Yes, please.
Sir, good morning. I am Vivek.
Yes, please.
Sir, Nisha Madam just come. So, after the break, I believe after 10 minutes, Nisha Madam can take up the session.
Okay, fine.
Okay. So,
till
Nisha,
that I may continue. Okay.
Yeah, please.
Okay, fine.
Okay, sir. Thank you.
Welcome. So let us resume on the slide that section 6, 7, 8. Section 9 is the initiation of CIRP by the operational creditor. Then section 10. Section 10 relates to the initiation of CIRP by the corporate debtor itself. If any corporate debtor has committed any default in repaying the dues of the lender, that company may suo motu initiate CIRP against itself. Then section 10A was inserted by way of an amendment, that suspension of initiation of CIRP, that was due to the pandemic situation prevailing all over the year in 2020 and 21, and still it is going on. And section 11 deals with the persons not entitled to make application of under section 7, 8, or 10. Disposal of applications under section 54C, under section 7, 9, or 10, that matter is related to the PPIRP that we will discuss when the PPIRP chapter will be discussed. Section 12, it provides the time limit. Section 12A, withdrawal of application admitted under section 7, 9, or 10. Then section 13, declaration of moratorium and public announcement. Moratorium, section 14, public announcement of CIRP. Then appointment and tenure of IRP, that is covered under section 16. Then management of affairs by the IRP as a going concern, section 17. Section 18, duties of the IRP, personal to extend cooperation to the IRP, and management of operation of the corporate debtor as a going concern, section 20. Today we will be discussing up to section 20 only. Why I have mentioned all the sections on this slide, that these sections are very much important and prominent. Students may remember these sections so that while addressing the question in the examination hall, if you are writing the correct section, it will have a positive effect on the evaluator. Then some of these sections are committee of creditors, appointment of RP, that we will discuss in the later session. But today we are discussing up to section 20. Then meeting of the committee, duties of the RP, rights and duties of the authorized representative of the financial creditor, and application for avoidance of transactions not affect to the proceeding. Then there are other sections: replacement, approval, preparation of information memorandum, persons not eligible, submission of resolution plan, approval of resolution plan, then appeal and liability for the prior offenses, etc. So total CIRP process is relating to this up to section 32A. So before we proceed, let us have a broad idea that how this CIRP process begins. So let us take an example that ABC is a company. That company has availed loan facility from the bank. That company has defaulted in repaying the dues. The dues may be in terms of installment or not providing the financial proper for renewal of the working capital limits. So the primary point from where the CIRP proceedings may initiate, that is the default. Availing of loan is not a default, but not repaying the dues is the default. So the focal point is the point when the company or the corporate debtor met the default. So what will happen? That company has met default in repaying the dues. Then the financial creditor who has given the loan will move an application to the NCLT for initiation of CIRP under section 7 by the financial creditor, or under section 8 by the operational creditor. What will happen? application to the NCLT means the initiation date. It is not the commencement date. It is the initiation date. NCLT will examine the application filed by the financial creditor or the operational creditor, as the case may be. Then it will decide whether that application has to be admitted or has to be rejected. If it is complete in all respect as per the provisions contained in the code and regulations, it may accept the application. The moment the application is admitted or accepted, the date, it is called the insolvency commencement date. Clear? When the NCLT finds that the application is incomplete, it may reject the application and give some time to the applicant to make it a defect free or make a revision of that. If the application is admitted by the adjudicating authority, it may declare moratorium. The moratorium period may be for 180 days if it is not extended beyond the 180 days. So declaration of moratorium. What is the effect of the moratorium? That we will be discussed in section 13 and 14 in the next slide. Then the moment the admission of application is accepted by the NCLT, moratorium is declared, the IRP is appointed by the NCLT. Always remember that insolvency resolution persons is always appointed by the adjudicating authority. It means it is an officer appointed by the NCLT. Any hindrance in the activities or the duties discharged by the IRP will be treated as contempt of court. Then IRP may have the option to make a representation before the adjudicating authority, and the adjudicating authority may give a proper direction to the corporate debtor to support or to provide all the facilities which the IRP is demanding. The moment the IRP is appointed, IRP has to make a public announcement by way of publication in the newspaper or on the website of the corporate debtor or on the website link provided by the IBPI. After the public announcement, the IRP is to constitute a committee of the creditors. Whosoever is having a financial stake in the corporate debtor, that financial creditors will form the part of the COC. Please remember that operational creditors are not part of the COC. Only the financial creditors can be the part of the COC. You may ask that if in any case where there are no financial creditors, there is another provision. In that case, the operational creditors may form the part of the COC. But primarily, if the financial creditors are available, operational creditors are not the part of the COC. They can attend the meeting, but they cannot vote. Then IRP will convene a meeting of the COC, and in that meeting, the committee members, that is the creditors, will decide whether to continue with the same IRP or replace another person as RP. If another person is not appointed, then the same IRP will be treated as IRP, and he will take care of the management affairs of the company. He will prepare the information memorandum, and he will advertise, and expression of interest will be sought by the RP from the resolution applicants. If the committee of creditors decides that the resolution plans submitted by the resolution applicant is effective, suitable, and approved by the majority of the COC, then after approval of that plan by the COC, that proposal will be moved by the resolution RP, resolution professional, with the adjudicating authority, and adjudicating authority will either approve it or reject it. If it is approved, then the plan will be treated as approved, and if it is rejected, then the NCLT may order for liquidation or winding up of the company. This is the flow chart. So now in the succeeding slides, we will be discussing how the COC, how the moratorium, how the management as a going concern will be performed by this IRP or IP that we will discuss. But in this flow chart, we have discussed at a broad level that how the CI process may be conducted. Section 6. Section 6 is the starting point of this CIRP, that who may initiate the CIRP where a corporate debtor commits default. The primary focal point is the default. So whenever a default occurs, a financial creditor or an operational creditor or the corporate debtor itself, if the corporate debtor has made a default, it may itself initiate application for CIRP. That is contained in section 6. Now come to the section 7, which is the prominent part on the prominent section on the part of the financial creditor, because this section depicts the process of initiation of CIRP against the corporate debtor. CIRP may be initiated by filing an application with the NCLT when a default has occurred by a financial creditor, either by itself or jointly by other financial creditors. Suppose one bank has provided and the corporate debtor has defaulted, that single creditor may initiate application, or that single financial creditor along with the other financial creditors may combinedly or jointly initiate the CIRP proceeding. And any other person on behalf of the financial creditor, as may be notified by the central government, may initiate the CIRP against the corporate debtor. Now, government has provided a notification in February 2019. According to this notification, the following persons may file an application for initiating CIRP against a corporate debtor before the NCLT on behalf of the financial creditor, which are a guardian, an executor or administrator of an estate of the financial creditor, a trustee, or a person duly authorized by the board of directors of the company. Financial creditors, as referred in section 21(6)(a), subclause A and B, the first proviso to section 7(1). It provides that for the financial creditors referred in this section, an application for initiation of CIRP shall be filed jointly by not less than 100 of such creditors in the same class, or not less than 10% of the total numbers of such creditors in the same class, and whichever is less. So both these lines, either 100% or 10% of the total number of such creditors. Then a reference has been mentioned, that section 21 subsection 6A. So what this subsection 6A describes about? It describes that where a financial debt is in the form of securities or deposits is owed to a class of creditors exceeding the number as may be specified. For example, a company has accepted deposits from its members, and the company is not able to pay the money to the depositor, then this section 21 by 6A comes into the picture. And in that case, the initiation of CIRP may be made by not less than 100 of such creditors, or not less than 10%, whichever is less. Similarly, if a person has booked a flat in a real estate project and the builder or the developer is not providing the possession of that flat in a time-bound manner, whatever the time has been mentioned in its prospectus when the home allottees have booked the flat, then not less than 100 of such allottees, or not less than 10% of the total number of such allottees under the same real estate project, whichever is less. Let us take an example that a builder, say Omkar Builder in Bombay, is having 5 projects, and all the 5 projects are running simultaneously. Some of the person have booked flats in A project, some of the another persons have booked flat in project B, and like that project C, D, and all that. The persons who have not been given the possession in a time-bound manner, then only the project A, in which the home LOTs have booked the flat. So the total requirement, that is the 100 of such LOTs or total number of such LOTs, 10% of such LOTs, whichever is less, may file application for initiation of CIRP against that builder only for project A, not for the other projects. Because other projects are, if they are running or giving possession or running in the on time, that projects are not to be disturbed. Only the project in which the home LOTs have booked the flat, for that only that project will be considered as a initiation of the CIRP. Then how to make the application? In which form? The form has been prescribed in the Insolvency and Bankruptcy Application to Adjudicating Authority Rules 2016. Please pay attention. It is the rules, not the regulation. The rules have been prescribed by the central government. So Rule 4 of this prescribed form number 1, and it depicts that a financial creditor either by itself or jointly may make a initiation of CIRP in form number 1 along with the documents. And what other documents are to be affected with the application? That if the applicant is an assignee, the assignee's agreement is to be attached, then where it has to be served? It has to be served on the registered office of the corporate debtor and to the board by the board means IBBI by registered post or speed post before filing with the adjudicating authority. And in case the application is made jointly by the financial creditors, they may nominate one amongst them to act on their behalf. And what is the filing fees? The filing fees has also been prescribed in the said rules. That is, if initiation of CIRP is made by the financial creditor, the fee is 25,000 per application. If the initiation of CIRP is by the operational creditor, the fee is only rupees 2,000. So you may remember only 2,000 rupees for the operational creditor. For financial creditor and for corporate debtor, the fee is the same, that is the 25,000 rupees. Just to remember, so you may remember only initiation fee for initiation of CIRP by the operational creditor, it is 2,000. For rest of the two, it is 25,000. Then section 7/3. The financial creditor shall, along with the application, furnish the record of default recorded by the information utility or such other evidence or record of default as the case may be, and the name of the resolution professional. At the time of filing the application in Form 1, the financial creditor has to name a person who will act as a resolution professional. So where the financial creditor will search the name of the resolution professional, every 6 months, the IBBA displays the panel of the RPs who are willing to conduct this CIRP assignment and are having the authorization, AFA. So the panel is available on the website, and every 6 months, this is being revised. And any other information as may be specified by the IBBA. Then record of evidence or default by the financial creditor, that is contained by the regulation, Insolvency Resolution Process for Corporate Persons Regulations, Regulation 2A. It provides that for the purpose of Section 7, Subsection 3, Clause A of the Code, the financial creditor may furnish any of the following record or evidence of default. As we have discussed, that primary focal point is the default. So we have to provide the evidence of default. How the evidence of default will be provided? By way of certified copies of the relevant accounts with the bankers, as per the Bankers Books Evidence Act, or any order of a court or tribunal that has adjudicated upon the non-payment of debt where the period of appeal against such order has expired, and ascertainment of existence of default by the NCLT. Now, when you are filing the application with the NCLT, now the NCLT has to judge whether the application is in perfect condition and there is existence of the default. If the default is not in existence, your application might be turned down. So the adjudicating authority will decide that there is an existence of the default. This adjudicating authority shall, within 14 days of the receipt of the application from financial creditor, ascertain the existence of default from the records of an information unity or on any other basis of the evidences furnished by the financial creditor. So time limit is given. In some of the decided cases, the court has opined that whether this time period, 14 days or 10 days or 7 days, wherever it has been mentioned, it is a mandatory or directory. It is not mandatory, but it is a directory, so that it is a given within the timeline has been given, but it is not mandatory. Some few days may be plus or minus, but it is a directory as has been provided in the IBC. If the adjudicating authority has not ascertained the extent of default and passed an order within such time, it shall record this decision in writing for the same. If the adjudicating authority finds that default has not been occurred, it will reject the application with some remarks on the application that why it is being rejected. Subsection 5 of section 7, subclause A, admission. When there is no disciplinary proceeding against the proposed resolution plan, application is complete, default has occurred, the adjudicating authority will accept the application. When the default has not occurred or there is a disciplinary proceedings is pending against the proposed resolution plan, it may reject the application. When the adjudicating authority is rejecting the application, it may give a notice to the applicant to rectify such defect, and the time period is given within 7 days to rectify such defect. CIRP shall commence from the date of admission of the application by the NCLT. If it is accepted, then it will be commenced from that date. The adjudicating authority shall communicate. If it is accepted, it will communicate to all the concerned person to whom the admission of the application to the financial creditor and the corporate debtor. And if the application is rejected, it has to be communicated to the financial creditor only. That is within 7 days of the admission or rejection of such application, as the case may be. Now we come to the insolvency resolution by operational creditor. So far, section 7 relates to the CIRP initiation by the financial creditor. Now section 8 and section 9 deals with the initiation of CIRP by operational creditor.
Thank you, sir. Thank you, sir, for making the students aware of this section, up to section 7 of the IBC code. As far as, first of all, I would like to wish every student a very good morning, and it's an immense pleasure to share with you through this platform. And I myself, Nisha, Faculty Board of Studies, welcomes you all on today's session. In today's session, my dear friends, you must be seeing that, sir, Dr. C.S. Rajiv Babel has made you conversant with the important aspect of the Insolvency and Bankruptcy Code. He has not only made you know why this act was actually required, in fact, has also made you to know the relevance of the code. In spite of there were many insolvency-related laws, but why there was a need of a one single statute to control the different sort of state of the Insolvency and Bankruptcy Act. So very well, sir has explained that why this act has been enacted, and further, what was the relevance of the code in the today's scenario. Along with that, he also made you how the act is developed and come into its present form. So, my dear friends, you must be seeing that how this act has come into enforcement and why there was a need of such an one single code to regulate the different sorts of insolvency and bankruptcy situation. In fact, if you see, there has been, you must be seeing that there were different scenarios and different things have been enforced and added in the code to regulate different sorts of the situation for the different sort of the entities. So, in fact, you must be seeing a lot of changes has come into the code. Still that time it has been enforced. It has been enforced in 2016, and from 2016, many amendment has come to the code. Even initially in 2018, the amendment has been made in the code. And after that, many amendments to Second Amendment Act in 2018, many relevant sections have been amended to be tuned with the regulation and conduct of the insolvency of many corporate entities, besides not only corporate entities, but also of the firms and individuals. Though the sections related to firms and the individual has not been enforced as of now, but only related to the personal guarantors of the corporate persons. So I would like to say Dr. Rajiv Babel is a very, he's a company secretary as well as he's an insolvency professional. And he is also holding number of degrees along with many diploma courses. So he has been apprised you with the important concepts that are relevant from the academic points of view, because they are forming the part of your syllabus. So you are being required to know the conceptual understanding of that particular section. And even I am here to let you know, to make you acquaint with the subject on the topic from the examination perspective. So this Code of Insolvency and Bankruptcy Code is covered in the economic law part of your paper 4 of your core paper, Corporate and Economic Laws. And this topic is very important. In fact, in examination, around 9 to 10 marks questions are being asked from this particular topic, including the MCQs. And if suppose later on in the group setting, you opt paper 6D, which is an elective paper, so definitely this topic is also being covered over there, and it shall be covering 30% of the topic. And at that time, it will be of a great helpful to you. So this is the base time. You can build your base strong. You can understand the concepts very clearly, and so that you can get the fruit while whenever you opt for the elective paper 6D. So at this level, if you have seen, we are covering up till section 59 of the code. So in this chapter, we will be covering the relevant definitions, then provisions related to CIRP, and of course, the new introduced chapter 3A, that is the pre-packaged insolvency resolution process, fast-track insolvency resolution corporate process, and voluntary liquidation of the corporate persons. So up to here, we have restricted the coverage of the code in our paper 4, and also covering the relevant rules and regulations. Since we have not covered the entire code, including the rules and regulations, we have covered an overview of the subject. And in the overview of the subject, so you are required to know only those rules and regulations and the sections which are covered in the study material. That means to the extent covered in the study material, they are relevant for you. So accordingly, you have to go through such rules and regulations and the provisions which forms a part of the study material, and they are relevant from the examination point of view. Now, the next question that generally comes in the minds of the student, what sort of the questions are being asked in this particular question? So let me tell you, basically, your examination paper, if you have already seen it, that's very nice, but let me give you a brief introduction on the paper pattern. If you see, there are total 6 questions. First question is the compulsory question. And in the compulsory questions, you must be seeing there may be either 2 or more subparts. So one part will be asked from the corporate law portion, and definitely the main compulsory questions will be comprising of corporate law portions only, while in the rest of the question, one part will be comprising of the corporate law and the other part will be comprising of the economic laws. And since this Insolvency and Bankruptcy Code forms a part of the economic laws, so it does not form the part of the compulsory question. Let me tell you very frankly, if you're seeing the last year past paper examination papers, you must be finding that no compulsory question is asked from the economic law portion. So in the rest of the question where there are choices, in remaining questions, the economic law portion may cover the question from one of this topic. And you will be finding that the question which is asked from this topic is of application and analysis based. So as a whole, if you see, the question paper is comprising of 3 types of questions. One is evaluation and synthesis based, which means there will be an integration of more than one provision. So generally these types of questions is question number 1 of your examination, where they generally ask the question where they ask on the basis of integration of 2 or more sections. For example, suppose in the Companies Act, if the question they ask about the appointment of the director, then definitely in the same question on the basis of the same information provided with the add-on information, they may ask another question that may be based on 167. So there is an integration of 2 different provisions. So these types of questions are said to be of evaluation synthesis based questions. So generally this is question number 1, which is of evaluation and synthesis type. Then second type of the question that from the majority of the questions in your examination paper is of application and analysis based. So there they check the application of the law. They check your knowledge and understanding in the given scenario, how you will apply the law. So that is the application and analysis based of questions. And further is the CK based, that is comprehensive and knowledge based. So they generally test the understanding of the provisions. So when we talk about the Insolvency and Bankruptcy Code, the nature of the question that we have defined is of analysis and application based. So what happens in such types of questions, they give you a small scenario or the situation, and there you are being asked to apply the law. That means application-based question. And then they say, analyze the given situation in light with the given provision. So this is the application as well as of analysis-based questions. So for example, let me give you an example of a question. Now suppose there is a Limited, which is a micro enterprises under the Section 7 of MSME Development Act 2016. It has filed an application for initiation of pre-packaged insolvency resolution process under Section 54C of the IBC Code. Now you have been appointed as a resolution professional to conduct the pre-packaged insolvency resolution process. Now Limited has prepared a base resolution plan and presented to COC for its approval. And the COC, while evaluating the base resolution plan, realized the plan impairs the claims owed to few operational creditors. Now, being in the capacity of resolution professional, you are required to advise the COC on whether it is mandatory for them to approve the base resolution plan, and if not, the process in which they can invite the alternate resolution plan. So you can see the nature of the question. You have been given a situation that there is one company. The nature of the company is also being mentioned, that is a micro enterprises. And further can say it had initiated a pre-packaged insolvency resolution process. And further, naturally, as sir has already told you, the resolution professional is being appointed for the conduct of the insolvency resolution process. So here, as a resolution professional, you are being appointed. Now, you are being asked what will be your stand if in case that the company Limited has presented the BSR for the approval of the COC. BSR is this base resolution plan they have presented for the approval of the COC. And in that case, what happens? They are seeking the COC's approval and evaluation whether that base resolution plan is appropriate or not in the given situation to run the company, or whether that company may survive or not, or whether the company may be revived or not. So in that case, you are being asked your opinion. Now, this is the situation given in the question. Now you have to examine the question and check properly what is the requirement of the question. That means you have to give the answer as per the requirement of the question. So now what the question is asking for? Question is asking for that whether it is mandatory for the COC to approve the base resolution plan. If not, then the process in which they can invite the alternative resolution plan. This is how the application-based question is being asked. Now, how you can reply such types of questions? Let me tell you one thing very frankly. These types of questions are generally having, marking breakup marks are there. Means you can easily secure good marks in such types of questions. So you will see every step has the marks. If you are writing the provision has certain marks. And when you point out proper the legal issues in line with the legal provision, as well as the finalized conclusion in line with that legal provision, then definitely every step has been allotted marks, and you can, on writing each and every step, accordingly may secure the marks. So here in this type of question, you first write the legal provision. Of course, in the given situation, you have to mention the legal provision. If it's possible, mention the section number. Being a final level student, it is being expected that you may cite some of the important sections, the main sections. to try to remember the main sections related to that particular provision. If I'm talking about pre-packaged insolvency resolution process, it may be possible that you may not be able to remember the subsections or every sub number or clause of the section, but yes, the main section. And here the main section is 54. Simply by mentioning section 54 of the IBC code, you can start up your answer. You can write down as per section 54 of the IBC code. Then you can mention what are the requirements that corporate debtor has to submit the resolution plan to the resolution professional, okay, for the approval of the COC. And then what are the further requirements, whether they will approve, in what condition, and if they're not going to approve, then what shall be the next situation. So first laying down the provision, and once the provision has been completed, it is not required to mention the entire provision. It's sufficient if you lay down the main essentials required to fulfill the requirement of the question. Just mention the main part of that particular provision. It pertains to that particular requirement of the question. Simply lay down that, and after that, lay down the legal issues that have been pointed in the question. Since in the example that I have given, I have mentioned that A Limited is a micro company, micro enterprises, and is undergoing this pre-packaged insolvency resolution process and has prepared BRP that impairs the claim of certain operational creditors. So in such a case, as per the provision, you can mention that RP and resolution professional can either invite they can either say they can rework on that particular plan, the suggested plan, or what they can invite for prospective alternate plans from the prospective resolution applicants, and they will decide whichever plan is best and appropriate for the company. So accordingly, they may decide which resolution plan is to be approved. So this is how you can lay down your answer. Conclusion also parts a part of the answer. It also has a mark. So along with the writing of the legal provision, legal issues, in link with the problem, and then the conclusion will make a complete answer. This is what is being expected in order to be a quality answer at the final level. This is how you can lay down the application-based question. So this is about the length end of the question and the expectations. And if at this point of time, because this session is for November 2022 examination, those students who are appearing over there, even for May 2022 exams also, students can see this lecture and derive the benefits. You can see what should be the planning strategy. It should be started from the beginning only. So what is the requirement for planning and preparing for the examinations? So what are being required that you need to have, that you should refer the latest relevant edition, which is relevant for the respective examination. So for May 2022 examination, as well as for November 2022 examination, the relevant edition is, of course, October 21 edition of the study material. So you have to refer this latest study material, and along with the latest study material, there is also required to refer the relevant amendments. Relevant amendments are separately hosted on the website also, and besides that, they are also given in the RTP. So refer the relevant amendments. Then you have to also refer the MCQs case scenarios booklet that is available on the website. Since 30% of marks are allotted to the MCQs portion, you are aware that MCQs portion division A, or part A of the paper is the MCQ type, which is of 30 marks, and the descriptive paper, which is of 70 marks. So you need to know what type of the MCQs questions are being asked in the examination. So in order to understand the types of the questions that are being asked, you need to refer the MCQs booklet. The MCQ booklet contains the nature of the question, the types of the question. Again, in that MCQs also, there is application-based questions as well as direct or knowledge-based questions. So just go through the booklet in order to understand and revise the subject and what type of the questions being asked in the examination. So latest edition, January 2022 edition is available on the website. Even you will see that this 30 marks segment of MCQs is divided into case scenarios as well as independent MCQs. If you talk about the case scenarios, yes, there is a situation. A one-page fact is given in a question, which is laid down the information. And after that question is being followed by 3 to 5 MCQs. pertaining to that particular information given in the form of case scenarios. Then you will be finding that independent MCQ types of questions. It contains small scenarios and independent scenarios, and on the basis of that, the question is being asked for. So whenever you mark for this MCQ types of the question, the answers, so you must be having a proper conceptual understanding of the concept, because the options given are so near to each other. Unless and until you are not clear in the subject, you're not clear in the understanding of the subject, you will be confused. So you have to find it out, the correct option, and also that too, sometimes giving a first glance to the options, you may find that every option is correct. So you need to read the question properly, read the options properly, and the option which is most appropriate, that is to be marked. So take care and read the questions properly with respect to MCQs part. Further, there is also that after reading the subject, there is an RTP. The time when the RTP comes in your hand, you are already through with the subject. You have already read the subject in a comprehensive manner. Now, what the thing is required, you have to read the RTP. RTP, in fact, it laid on the question which you have to proceed to solve the questions at your own first. And then later on, you have to refer the answers given in the RTP so that you can access your level of preparation. So it's required to refer the RTP and also read the amendments given over there. After this, you can refer the suggested answer for practice. You know that this is the practice which gives a finishing touch to anything. So practice is a must. So for practice, you can refer last 3-4 attempt suggested answers. Don't refer too much earlier papers, because since law is a dynamic subject, it has been constantly changing. So it's better to refer the latest 2 to 3 attempts past question papers in order to understand the different sorts of the question that has been asked in the different topics. And from that suggested answer, you can also analyze and do your working that what are the important topics on which regularly the question is being asked from. So you can come across with the important relevant provisions. Just mark it that these are the relevant provisions on which regularly the questions are being asked in one or the other form in the examination. So do a that exercise, and after that, try to attempt MTP, mock test papers, in the same situation as you undergo in the examination situation, so that you can analyze or you can assess your level of preparation. And also you will come to know where you are lacking. You can know your gray areas, what you have missed out. So after doing that, you can cover up those areas also, which earlier you have not taken into consideration, but now after just appearing in the mock test paper, doing the mock test paper, you will come to know it. Most important thing is live coaching classes. As you all are attending, these classes are very important. In fact, it is the greatest initiatives of the Board of Studies. All the renowned subject faculties are coming and taking up the session on this subject to give you enhanced coverage of the subject, not only from the academic perspective, from the practical aspect also, so that your overall development is there, not only from the academics point of view, but also when you move at professional front, you will definitely gain from them the practical exposure on the subject. Besides that, there is many other facilities also available. Apart from the live lectures, you will be finding that many assignments and notes are being uploaded on the website for the benefits of your students. In all the papers, you will be finding that the faculty, those who are taking the sessions, they are uploading their notes so that your notes can be referred. In the future, further, they are also provided the assignments in order to check understanding of the subject. So you can refer all these things. Since many of your students are not very well aware where these all facilities are available, so let me just give an insight to how you can go and find out all these facilities available. So I'm just sharing with you my screen so that you can derive the maximum benefit and you can find out what all facilities are available with you, because many students are not aware that where all these facilities are there. And every time we apprise the students, yes, these are all for your benefits. And that is why I'm just sharing my screen in order that you may understand and find out all these things, and you can refer and drive the maximum benefits.
Sir, can you stop your sharing screen?
Yes. Yes, please.
Okay, sir.
Yes, friends, you can see that this is our this is our BOS. This is the main home page of our live virtual live coaching classes wherever it takes place. So you can find that the link provided is live.org.org/BOS.L/VCC/final. So simply by logging on this, you can open this home page of the class. So you will be seeing that here different types of tabs are there. One is of the live class. Whenever you want to see the live class, you can simply go on the live classes. Here, whatever the classes are running live, you can simply see that class. And then one of the profit of the live watching of live class is that you can simply ask the questions or the issues of the query at the very moment while watching during the session. And I expect that you students should drive the maximum benefit by watching these live classes, because when the sessions are being taken by the experts or the subject faculty, at that very moment, whatever the issues comes in your mind, you can directly raise that issue at that very moment, and you can come up with your issues at that very time. Because sometimes it happens later on, we get skipped up all those issues, but at the very moment when you ask the skip, you correlate every thing in a proper manner. Then second tab you are seeing of the recorded lectures. Since you can see here, there are available all the papers, the different recorded lectures taken by the different faculties. So whenever, suppose you have missed the live classes, then you can simply go on the recorded lectures. These are available here. And whenever you want, at any time, anywhere, you can see these lectures and gain the profit. Similarly, you can see the downloads of notes. Every notes are available and being shared by the faculties. So whatever class is taken by any of the faculties, they share their notes with you in order to refer later on. Similarly, when you then the next you will be seeing there's another tab related to feedback is also there. Assignment is there. Then assignment, when we talk about the assignment, you can simply refer the assignment part. There you can see the different faculties have posted certain exercise for your recall of the topic. So in reference to that particular topic, they simply make you available the assignments. Simply by logging to the assignment and doing the assignment, you can access your understanding of the subject. So whatever being taught, you are being able to understand the same. And after that, there is a feedback form. So whatever you feel like there's a chances of improvement in the subject, through feedback form, you can simply mention the same so that we can take care in the future and make it more beneficial to you students. So this is about the live coaching classes that I have shown you. Now, these are certain other initiatives that I would also like to bring to your notice. Not only the initiative, it is our main website where all the related resources are available for you students. If you see the main website, ICAI.org, simply log in and you will be finding different main tabs: home, overview, committees, members, students. So simply log in to the students tab. And after logging the student tab, there's a BOS knowledge portal. Kindly click on the BOS knowledge portal. And after clicking on the BOS knowledge portal, you will be finding the different sorts of the resources available over there. So one of the resources with respect to the study material. So you must be seeing that paper 4, corporate and economic laws, which I've already opened here for your references. You will be finding that here there's a study material. These are all the study material which are relevant for your examination. Simply it's reflecting the study material applicable for May 2022 examination. So these are the latest study material. If any corrigendum or anything is being related to hosted on the website, you can also refer the same. So kindly keep regularly visiting our websites in order to understand what are the latest updates related to the subject or related to any of your things related to the academics part. Similarly, you can also see the relevant amendments. As I said, that apart from the study material, one has to refer the relevant amendments also. So separately, these amendments are being hosted on the website. You can see here, these are the relevant amendments which has been made applicable for May 2022 examination. So here everything has been given in detail, what are the relevant addition, up to what it is covering the amendments. And apart from these amendments, the other amendments have been mentioned separately here. They are also relevant. Even you can see the reference of the page number of the study materials given for your easy reference, so that you can find it out and you can make changes accordingly in your notes or in your reference books while reading your subject. Then you can also see if any announcement has been made with respect to any of them, everything will be available on this main subject tab. So kindly regularly visit the websites in order to be aware of what are the latest updates are going on related to any of the subjects and to be in touch with that. Similarly, you can see the MCQs and case scenarios booklet. This is very important, my dear friends. Again, I have said this portion forms the 30% segment of your paper. So you will be reasoning that here all types of questions, that types of being relevant and that are being asked in the examination, you can check across with it and then you can refer the same and revise the concept and go with it. So these are all the things that have been provided in the Board of Studies portal, and you can refer the revision test papers, the latest, all the revision test papers are available here. Then you can see the suggested answer, all the past suggested answers of 4 or 5 attempts are available here, which you can refer and do continuous practice. Similarly, the mock test papers which are made available for practice are available. So you can also simply by logging here, you can download the MTP and attempt the same. If you want to refer the past question papers, that are also being made available. One most important thing that I would like to bring to your notice is the referencer for the quick revision. Many of the students are not aware of this initiative of facilities that are being available for the benefit of the students. You must be finding that these are all the details we have given the format. These are certain topics which have been represented diagrammatically or in a flow chart to make you understand and revise the concepts easily. For example, I'm just showing here, for example, chapter 1, you can see for appointment and qualification director, we have represented the important relevant provisions here in the diagrammatic manner or in the tabular manner in order to easily recall, retain, and read the legal provision. This is of a great benefit. This is a kind of a key notes for your students. So you can simply, instead of making your own notes, you can also refer these notes while doing final revision of the subject for the examination. It is given in a simplified manner. It is catchy and it is easy to retain the important points in a legal provision. So this is what the facilities have been provided over here. The next thing is, the next thing that I would like to bring to your notice is about the examination tips. Given as of now, I have told you how you can prepare for the examination, how you can plan for it. But now I am focusing on that what shall be the examination tip. For examination tip, I am just saying that how well student fares in an examination, that depends upon the level and the depth of his preparation. But there are still certain small tips that needs to be taken to hone your skill of representation of the answers. Means representations makes a difference. That means sometimes you are aware with the legal concept, but it is just the writing that makes a difference. Okay, so there are certain tips, the small tips that I'm going to just tell you, though it seems to be very general, it seems to be small, but let me tell you, it is of a great worth to you. It is, that success, it is a sum of small efforts that you put into it. So this is something, the common things we will be doing uncommonly, you can say that. So what happens, these are the things, whenever you receive the question paper, you get the 15 minutes time for reading the paper. Read the question paper carefully and properly, first of all, and then decide or plan your time, the appropriate time given to each and every question in the paper. So what happens, the question which you can answer in the best manner, start with that particular question. And also you have to complete the entire paper. So this proper allocation of time, as I said, is required to be given for each and every paper, so that you can complete the whole paper and do all the questions in a paper. Further, you need to read the questions carefully before starting the question, so that you can understand what is the requirement of the question. So every time before you start the question, though you have read the question during that 15 minutes time, but whenever you start the question while attempting the paper, you need to read the question properly once again and just see what is being required or what is being asked in the question, and then start your answers accordingly. And the steps already I have told you how you can lay down the answer. If it is simple knowledge and comprehensive based question, then there is no issue. You can simply lay down the legal provision and complete your answer. But kindly look that the answer should be in commensuration with the marks allotted to that question. If something is asked for the 5 marks, you cannot lay down in 4 or 5 lines. You are being required to fulfill that the question's requirement, and in commensuration with the marks, you have to lay down the relevant part of the legal provision in line with the legal issues as well as the conclusion to complete the requirement of the question. Further, the other thing is that answer all the parts of the question. You must be seeing that every question has certain parts, sub-parts are there. So what happens in that case, you need to answer all the part of a question at one after the other, and do not answer the different part of the question at different places. Matlab, of the same question, if there are many parts, lay down at one place, one after the other, not at other different places. So that may also be confused the paper setters where you have laid down your answers, and sometimes it may be possible that you may miss some of the questions, and that is a drawback actually. So what is being required should be laid at one place only of the same question. It should be neat, and it should be in a legible language, and it should be easily legible. So it should be written properly. Along with that, answer should be concise and to the point. It does not require to be field page unnecessarily. Okay. And your answer must be in a logical expression. This is what expected at the professional level. Nothing should be written big over there. Whatever is required, only that information needs to be there in the answer. And further, wherever the question is not clear in itself, so you can simply lay down the assumption or the presumption and then give your answer in line with that, the questions. Further, as far as MCQs part is concerned, then you need to, that is what I said, that you need to read the question properly because the options are very near to each other. So mark the appropriate answer in the given situation. So this is the general tips that I have given regarding the examination as well as the planning strategy that I have discussed with, and all the initiatives that have been taken by the BOS for the benefits of you students. Also the resources, the different resources that are available for the benefits of you students. So with this, I would like to just say thanks to the sir, and I suppose the queries, sir, is there any queries?
None of the students has raised any query, but I will prepare some questions and will give some assignment, and if the students like so, then I will evaluate also.
That will be great, sir. That will be 100% great for the student. For the benefits of them, they can refer anytime that queries at their convenience. Dear students, thank you once again for patience listening and for just paying attention for whatever we have given you, our thoughts and shared our experiences to gain to the maximum. And thank you, sir, for wonderful session. And students, whatever the sir has explained you or apprised you, these are very important aspects from the examination point of view. And up till section 7, we have completed. And on the next section, sir will be continuing with the further sections of this paper. Thank you, sir. Thanks a lot. And with this, all the best, students, and thank you.
Thank you, madam.